Hello, everyone, and welcome to a new session with the Rights and Responsibilities Awareness Initiative. Today, we are lucky to have Anju Fujioka with us to talk about a very important topic, which is the civil actions for sexual assault and abuse. Thank you very much, Anju, for being here with us today.
Of course, thank you for having me. All right, so let me just open this up and share my screen for you. Let me see. Okay, this should come very easily. So are you seeing my screen at the moment?
Yes, I can.
Oh, you are seeing my screen?
Yes.
Okay, perfect. So that should be there. Perfect. So I want to say hello, everyone, and thank you for having me here today. So I'll keep my introductions pretty brief here. My name is Anju Fujioka, and I am a lawyer specializing in sexual assault and abuse. So generally speaking, I wear a few hats. I'm a civil lawyer at Beckett Personal Injury Lawyers, where I help victims of sexual violence obtain justice and compensation. I also work as the Canadian sexual and gender-based violence expert in an initiative funded by Global Affairs, which takes me abroad. And then finally, I'm also the supervising lawyer for LISA, that's Legal Information for Sexual Assault, which is a pilot project at Western University that provides free and confidential legal information about survivors' legal options after sexual assault or abuse. So the last one's a pretty exciting project. It's a one-year pilot right now, and it opens up to any current student on main campus starting tomorrow, and it runs throughout the academic year. So as you can see, quite a few hats there, but all related to sexual assault and abuse. So today, the topic here that we'll be discussing is about civil lawsuits related to sexual assault and abuse. And why is this important? What is a civil lawsuit? Those are questions you might be having. And the reason why I think this is important is because when we talk about legal options after assault, or when we think about justice, or what can the legal system do for someone who's been sexually assaulted or abused, recently or in the past, the first thing that comes to a lot of our minds is going to the police, right? And that's sometimes the thing that's recommended to a lot of people is, go to the police, speak to the police about what happened. So absolutely, that is one option. But that isn't the only option. And these other options are the ones that are, that are not as well known, but can really provide some meaningful redress for survivors. So that's something that we want to cover. And one of those options includes suing the perpetrators or their employers or other people or organizations who might have been responsible for that assault or abuse in order to recover compensation for the loss that the victim or the survivor sustained. So that's what we'll be discussing today. And throughout the presentation, a lot of the time I'll be referring to the victim of an alleged sexual assault or abuse as the victim, the survivor, really interchangeably. I might also be using a lot of, I might be calling the victim she, not because, only women can be victims or female identifying people can be victims, but just because that, tends to be the case. And then we'll also be using some legal words, plaintiff, defendants, things like that. I'll be limiting my usage of it. So, it'll be as simple as possible. But when I do, I'll make sure to define them as I go along. And if my understanding is that this is being recorded and, questions can be sent in, that if there are any questions after either this presentation, if you're a live audience, or afterwards, if you're watching this on replay, feel free to reach out to me. My contact information is on this cover slide and in the materials kind of talking about this presentation. So you can reach out anytime if you have questions. Okay, so before we get started here, just a little disclaimer that we should put on. So on confidentiality, if there are any questions being asked during the Q&A that will follow an informational session, please keep the questions general. So nothing that identifies you or, nothing too specific about your legal situation or the questions that you have. That's something that's best addressed, in the confines of when you're speaking with a lawyer directly, as opposed to on a public forum like this. This presentation will be recorded and it'll be available online. So we want to make sure anything that's discussed isn't something that needs to stay confidential. And the last important piece here is that this is legal information, not advice. So what that really just means is I am not able to give any kind of tailored legal advice or recommendations about anyone's specific legal situation. All of this information that I'll be presenting is general. So I'll be talking about, generally what is a lawsuit, what are the options, what does the process look like, maybe what are some common misconceptions or some important things to know. But again, how things are done might change slightly from lawyer to lawyer. Well, they definitely differ from lawyer to lawyer, but also in terms of, the types of compensation available or any other details like that. That is all something that you want to speak with a lawyer about if you want to get specific advice about your case. So before we dive right into the world of civil sexual assault lawsuits, I think it's helpful to get a big picture overview. So if you're listening and you're thinking, is this something that is this an option for me? Or maybe you're listening to this because you think you know someone, right? And you might want to help them out. Or maybe it's just for general information. Either way, whatever the case, whatever your situation might be, I think it always helps to have an understanding of what that big picture is. What are these options that someone might have if they've experienced assault or sexual abuse. And I know I haven't really defined sexual assault or abuse in any precise way. I'm taking a pretty broad view of it. So, sexual assault, that can include, what I think a lot of people will call rape or non-consensual sexual touching. It can include, kind of penetrative acts. It can act, just touching with the clothes, anything that's non-consensual. Sexual abuse, a lot of times I use to refer to cases where there is this sexualized, unwanted, or non-consensual sexual conduct, but perhaps it was, prolonged over a period of time, or it's an abuse of someone's position of trust and authority. So there's this kind of abusive context to it. But again, keeping these terms very loosely defined, whether or not your specific situation, would constitute sexual assault or sexual abuse, or if you have options, again, something to discuss with a lawyer. But broadly speaking, if you have suffered, if someone suffered sexualized violence, then one of the first things to consider is safety. So that's physical and emotional safety. And so I know I am zooming in from London, and RAI is also based in London, but in London and surrounding areas that it services, one of the best places to get special medical attention after sexual assault is the St. Joseph's Hospital, because there we have the Regional Sexual Assault and Domestic Violence Treatment Center. A long word or a long term, but there essentially we have a team of specialized nurses, doctors, social workers, all who can provide care to people of any age, gender, sexual identity, who has experienced sexual assault or domestic violence. So there's obviously medical treatment, psychosocial support, referrals, if needed, that can be provided there. So if it is, especially if it's something that happened recently, very important to consider your medical needs. And there at the center, victims also have the option of getting medical evidence collected, or forensic or physical evidence collected. that's something using a sexual assault evidence kit. So that's sometimes referred to as a rape kit. It's not mandatory. No one will force you to do that without your consent. But, depending on how recent the act of sexual violence was, that could be, any evidence collected might be helpful in legal proceedings down the road. So that's something to consider. And if you're kind of looking in from other jurisdictions, they have similar sexual assault and domestic violence treatment centers across the province. So that's a place that you can look to for medical attention. The second option, the one that comes to mind pretty quickly for a lot of folks, is police. So contacting police and starting the criminal process. That process is mainly concerned with the guilt of the perpetrator or the accused person. And I should also note, in all of this, I'm kind of talking about the perpetrator, in language, I don't say alleged perpetrator or anything. We're just, assuming they are the perpetrator. I'll just be using that word. So in terms of reporting to the police, the one thing I'll say is it's always up to the survivor to determine if they want to do this, when they want to do it, when they're ready. Important points is that memory and evidence do deteriorate if it's on, people's memories, witnesses' memories. All of those do go away over time. So there are some benefits to reporting as soon as you're able to, physically and emotionally. But, again, it shouldn't be something that you're pressured to do if you're not in a place to do so. And the third option here, so contacting a lawyer. That's the one that, will be most relevant to this presentation. And by contacting a lawyer, I'm not talking about just contacting a civil lawyer for the purpose of for a lawsuit. I'm just talking, getting legal advice in general from a lawyer. That's something that survivors might want to consider. And it's something that is being done more and more, but it's not necessarily the first thing survivors think about. And that's fine, but I think, it's important to know that that is an option. Consulting with a lawyer doesn't mean that any given victim has to pursue a case in court. It doesn't mean that automatically you're testifying. No, you might just want to contact a lawyer to know what your options are, since information can be really empowering. And someone like me, a lot of my colleagues, who are working in this space as lawyers, we know a lot about the options available. We can, listen to what happened and tell you, oh, it sounds like these are the potential paths that you might want to take, or these are some of the options that you have. If something is a time-sensitive matter, if there are certain timelines within which you have to do things, we might be able to give you some advice on that. So, contact someone who is well-versed in that field, contact a lawyer, and they can help you navigate or at least understand your legal options. And importantly here, I'll say talking with a lawyer also has some benefits that don't exist always in other contexts. So anytime you consult with a lawyer, that conversation is privileged. And what that means is, it's a very, very high level of confidentiality you have with that lawyer. So for a survivor of sexual assault who has been a victim where the trust has been violated, that protection can be an important thing. It gives you some reassurance, and you're already starting off on a baseline of some trust that might not exist if you're just speaking with, say, a colleague, a friend, a family member, or even to the police. That's not a confidential conversation that you're having with the police. So it might, it never hurts to speak with a lawyer just to understand your legal options at that point. Now, finally, I should also mention that there are a lot of non-legal supports. I already alluded to the medical one, or I talked about the medical one, but there are other supports that a survivor might want to access. So these can include local sexual assault centers. They're great, not just because they can offer some short-term counseling or support or shelter if that's needed, but they can also refer you to other resources as well, which is an important thing. So here, for example, in London, we have Inova and we have but we also, everywhere you'll have your regional sexual assault center where you might be able to contact. There might also be counseling through school, your work, or your usual medical channels. That's something to consider. And then in Ontario, if you're a survivor of sexual violence, you're entitled up to 4 hours of independent legal advice. It does come up with some parameters, but there is an application that you can fill online. And down the line, I'll be doing a quick presentation on what that program entails, or what that is. But there are some sources, albeit limited, for independent legal information. So that's something to keep in mind as well. I know a lot of lawyers will provide some free consultation at the outset in this area, but those non-lawyer resources are also helpful to know about. Now, moving forward, and I think this is where a lot of folks, where you want to know a little bit more about when it comes to civil sexual assault, is what is that process, right? Why should I consider a civil lawsuit, or is a civil lawsuit an option for me? And then, what does that process realistically look like? So that's why now I'm going to talk to you about the typical lawsuit process, so you know what happens from the time you contact a lawyer to the time your case settles. And in that, this, again, I'll put a disclaimer that this is just a broad typical lawsuit process. It doesn't mean that every case is going to follow this. And it also doesn't mean that every lawyer is going to follow this specific outline, but it is, generally speaking, a civil lawsuit will resemble something like this. So when I'm talking about the lawsuit process, or the litigation process, I'll use two terms pretty often. The first one is a plaintiff. The plaintiff is just what we call the victim, or the person who is suing for compensation. So if I've been sexually assaulted, I'm bringing a civil lawsuit, I'm the plaintiff. And then the other word is defendants. So it's like what it sounds, you're defending the lawsuit. So these are the people or the organizations that the plaintiff is suing. So that could include the person who assaulted the victim. It can also include other organizations or people who either facilitated it, allowed it to happen, or in other ways legally responsible for that abuse or assault. So back to the process. The first step is an intake. So what is this intake? It depends from firm to firm, or lawyer to lawyer, but essentially, the first thing you do when you reach out to a lawyer is kind of tell them at least briefly what happened. So you might be speaking to a lawyer directly, you might be speaking to one of their interviewers, or like a intake specialist or someone like that, but you'll give them basic details about what occurred. And so if you're talking about sexual assault or sexual abuse, concretely, what are we talking about? It might be things like, when did this happen? Where did this happen? What kind of things, what types of acts were involved? And again, the purpose of this usually is not to re-traumatize you and get you talking about every detail. It's just so that, we're able to understand at least get a general sense of what this case is about. Who is this person, or who are the people who did this to you? Have you ever gone to the police? That is not an accusation. If you've never gone to the police, it doesn't really matter. It's going to police is not a prerequisite, but you might be asked about that. Who else have you told? What are the effects of this on your life, on your mental health, on your physical health, on your education or your job prospects, job history? Are you being treated for any medical or other conditions that are in some way related to the assault or abuse you suffered? These, how is this affecting you generally, right? Like, these are questions that might get asked at the intake stage. Again, typically they tend to be pretty, broad questions. We're not getting into too many specifics, but we need to at least understand, what this case might be about. In this intake as well, typically, you'll start, thinking about who these defendants are, so the people you'd sue or the organizations you'd sue. And we'll talk about it a little bit later, in terms of, what are these defendants, what can they look like? But generally, we're thinking about who might be responsible. So if we're thinking, let's say, it's a case where abuse happened in the family, right? Let's say it was a parent or a relative who abused you. Is there another family member who should have known or who knew and did nothing, right, while you were a child? Or another common one we'll see with institutions. So we're talking, scouts, or we're talking the church, or, or schools, right? Unfortunately, we see a lot of abuse there as well. So were you in a position where, say, for example, a student was abused by a teacher, or an altar boy or someone going to church was abused by a priest? In those cases, if all of this happens in an employment context where someone who was employed by an institution abused you or abused someone, then there are cases where you can hold that employer accountable as well. So you're not just suing the teacher themselves, but the school for having failed to protect you, or there are other concepts in law as well that just hold institutions automatically responsible for the conduct of their employees. That is the most simplified version of how I can put it, but it's a case by case analysis. But there are a lot of things that you think about. So you're not the only defendant is not always the perpetrator. There are a lot more people or organizations who could be responsible for what happened. So you start, they'll ask you questions about that, and that typically concludes the intake. It shouldn't take an absurd amount of time. We're just fact gathering. From there, you'll probably speak to a lawyer. At least that's the way we do it. So after the lawyer reviews this basic information, we have a sense of what the case is. Then we'll speak with you and get some more details if needed to better understand the case, if that's something that needs to happen. We might do some investigating, right, to figure out. Sometimes if things have happened a long time ago, we might need to know, is this person still alive? Or if it's a family member who's been long estranged, they're in a different province, you moved away from them when you were 13. Are they still where you last saw them? What are they doing? And if the only defendants are individuals, then we also do a little bit of investigation into do they have the ability to pay? Because that's it's very crass. Civil lawsuits do at the end of the day come down to money, right? Can you be compensated? So the defendants have to be able to pay you, whether in order for there to be a civil lawsuit. So if they don't have the means, if there is no money there, then I would recommend against pursuing a civil lawsuit, because it would be all for nothing, right? You go through the lawsuit process only to learn that you cannot recover anything. That's just really traumatic for any survivor. So we look into that and talk about, is this a viable case? Is this something that we can bring forward? And say you've spoken with the lawyer, you've done that intake, you've done these, you've gone into a little bit of detail, and you decide to go forward with a lawsuit. Then what happens is, well, maybe I should backtrack. So you've done all of this. In some cases, you can settle even before starting a formal lawsuit. So what does that really mean? So seeking compensation in a civil lawsuit doesn't always lead to going to court. So that's really important to remember. 90-some% of high 90%, so like 97, 98% civil lawsuits settle outside of the courtroom. So you're not testifying in front of a judge or a jury, and a judge or jury is not deciding your case. The case settles somewhere before it ever sees that point. Where in the process it settles, again, depends on the facts. But important thing to take away is that it's not, it'll likely resolve outside of the courtroom. Now, sometimes they're resolved even before a lawsuit's filed. So this would depend on a lot of factors, including what kind of evidence is there, have any admissions been made? So by that I mean, maybe has the defendant or defendants, right, like the perpetrator or other organizations that you might be suing, have they admitted that this wrong happened? And is it just a question of what should the compensation look like? Is there a criminal case, right? What was the outcome of that? Or is the defendant someone or an organization to whom their reputation is just so important that they want to settle this before a formal lawsuit is filed? there are a lot of things that go into whether or not something settles even before a lawsuit is started. It's not common, so that's something to keep in mind, but it happens. So sometimes this settlement before a lawsuit is formally started is, could be an option. Now, assuming that doesn't happen, assuming there's no settlement before a lawsuit, then we go on to the next step, is formally filing that lawsuit. And what that involves is filing a pleading is the legal word for it, but really it's just, the plaintiff or the victim by their lawyer is filing a document with the court that just sets out the allegations. So broad allegations of what happened, what you're trying to prove. And then the defendants have the opportunity to respond to that again. So that's the pleading phase. And then after that, you go into the discovery phase. So there are two parts of the discovery, the documentary discovery and the oral discovery. Discover just means that all parties in this lawsuit have a chance to understand and know the full scope of all the relevant information in the possession of the other parties. So that's a lot of words just to say, if in the documentary side of things, as the victim, you're supposed to produce or provide to the other side any and all information that could be relevant to the lawsuit. So what could that involve? If there's any evidence or proof of the assaults or abuses themselves, that would go in. If we're thinking, there have been letters written admitting what happened, that could also go in. But one thing that's equally important, if not more important in some cases, is evidence of those damages or the things that we're seeking compensation for. So medical records, right? Because they'll prove that suffering, that emotional, pain and suffering, the emotional harm done, treatment received. Also education records, employment records, those all become relevant because it can help illustrate the effect that the assault or the abuse had on your life. Likewise, there might be other records that you use on a case-by-case basis that you want to provide to prove your allegations or your claims for damages, because you're claiming that you were injured in certain ways. So you want any documentation about your medical or your education, employment, all of that becomes relevant. On the defensive side, so let's take a hypothetical. Let's say this is a case of a student being abused by their teacher, right? So if we take that situation, then you can see why all of those damage documentation becomes important. But on the defense side, the school board would also be someone who's sued. The teacher would be someone who's sued. So they would provide any relevant information they have about, the teacher's employment record at the school, any other complaints that they might have received about this teacher before you were abused, any disciplinary, or any write-ups or performance issues that they had, any documentation they have of things like that, they would be obliged to disclose to us. And the reason for this is that the civil process is created with settlements in mind. So they don't want to encourage people, the system doesn't want to encourage people to take everything to trial or to go to the courtroom. They want, open and full disclosure up front or as early in the process, so the parties know what this evidence is going to be and they can try and work out a resolution together without having to involve, courtrooms and judges. So because of that, there's this exchange of information that happens, and it's all protected there is a protection there. So this information that's provided for the purposes of lawsuits cannot be provided to third parties or used for anything other than preparing for this lawsuit. So this way, the parties are able to see the totality of the evidence, but know that it is, kept confidential within this lawsuit itself. So you do this documentary discovery. And then the next thing that happens is oral discovery. So what does that mean? It just means that there's the lawyers get a chance to question the plaintiff, and likewise, so the defendant's lawyers will get a chance to ask the plaintiff questions, and then later me as the plaintiff's lawyer will get to ask the defendant's questions. So in doing that, we're getting a sense we're getting more information, of course, asking questions, filling in the blanks that aren't there in this documentation. So that, for example, the plaintiff will be asked, not just about the abuse or the assault they suffered, but about, their life before, right? If it's abuse that happened in childhood, then, what was your home life like? What was, how were you in school? All of those questions will come up. How was your health, right? How was your relationship with family? And then we'll ask about the after, right? How was your education afterwards, your employment, your physical, mental health? And by doing that, they're trying to get a sense of the before abuse and after abuse life to really get to how did this abuse impact you? Similar thing with sexual assault, even if it happens more recently, even if it doesn't involve a minor victim or a plaintiff, you're still looking at what was your life like? How were you doing before this assault or abuse happened? And how are things now, or how did things change because of the abuse and the assault? Because that change, or that, the decline or those losses are what you're seeking compensation for. So after the discovery process, both parties have a lot more information about, the case that they have to meet. So they can see the totality of the case. And at this point, a decent number of cases will settle because the lawyers on the defense will have had a chance to, question the plaintiff and get a sense not just of, what happened or what are the effects, but also, do I believe this person, right? Do I find them credible? And so do I find them likable? Will they, do I think a judge or jury will believe them? Is there a risk to my client? So they'll look at this and they'll, a lot of times they'll consider entering into some settlement discussions. Not always, and it doesn't mean that their discussions will be successful, but that's something that oftentimes happens after discovery. Now, say it doesn't settle at discovery, and you'll see a lot of these points are potential points where things can settle. So say it doesn't settle at discovery, then mediation is a common thing. So in some jurisdictions or some locations, mediation is mandatory. In others, it's not. But for the most part, in sexual assault cases or sexual abuse cases, we do mediate, and that's it's a positive. Mediation is much less taxing in a lot of ways than, say, like going to a trial. It's a time where the plaintiff is with their lawyer, the defendants are with their lawyers, and then there's a mediator, a neutral party, whose job it is to kind of facilitate an agreement or settlement of the matter. They're not going to make any final decisions, so it really is up to the parties to come to an agreement. But this mediator is able to kind of be a neutral party between the two sides, or the plaintiff and the defendants, and kind of take those offers back and forth and help them come to some kind of resolution. So in the mediation, because this is not so adversarial, so it's not the victim against the defendant as much as it's trying to come together to a solution. Some survivors find this to be a much gentler process than, say, for example, like a criminal trial, right? Like where you clearly feel that adversarial nature of the process. And in sexual assault and abuse cases, because at this point, most of that evidence is already on that table, we're aware of the facts of the case. A lot of cases will settle at this point. Maybe 50% of cases will settle at this point. Don't take the number, it's just an anecdotal one. Now, say mediation doesn't work out, right? And you're not coming to an agreement, then the next step is preparing for trial. So if the plaintiff feels that the offers are too low and this isn't going to settle, or if the defense thinks, this is a case we can just win, or like not pay as much on, so we're just going to keep going, then we do what we call setting the matter down for trial. So what that just means is, you pick a date for a trial, and these are oftentimes years and years into the future. So it's not a short process, but you pick a date for trial and then start making preparations towards it. So that could involve getting expert reports. So, experts to testify, or experts to assess the victim and provide a report on the impacts of the abuse. It can be, the financial impact, it can be the psychological impact. It could have been a what if analysis of, what if this hadn't happened, where would you be in life? So we'll hire those experts. We'll start contacting witnesses and, getting them prepared for trial. And before it actually goes to trial, there's a step called pre-trial where a judge again, the parties meet with a judge and either try to narrow down the issues that might be tried or come to a resolution. But again, if cases don't settle up pre-trial, then and only then are you really going towards trial, and it's very rare. Like I said, 90-some% of cases, sexual assault cases, will settle before ever going close to trial. So a trial is very rare, but if that happens, then the parties and the witnesses are taking the stand, telling the story, recalling experts, and giving all of this information to a judge or jury who will then decide whether or not the perpetrator is responsible and how much money they owe in compensation, and under what categories. So very broad, picture of the litigation. Those are the steps, but I think what's important for a victim or a survivor to know is that there are a few key points. So the first one is contacting the lawyer and just giving that basic information about the case, right? Or doing that interview with the lawyer, just so we understand your case. That's the touch point number one. The next real main event that happens is the discovery, that oral discovery, where you're asked questions. And it's my practice, and it's the practice of, I think most reputable sexual assault lawyers, to really prepare the plaintiff ahead of this discovery, so you know what to expect, you're feeling comfortable. And then the next, big event was probably be the mediation. But these are things that are spaced out over a long time. So I typically say lawsuits will take anywhere between 1.5 to 5 years, even longer if it goes to trial. Much on the shorter end if we're looking at early settlement. So it's not something that should be at the victim's, at the front of a victim's mind all the time, 24/7. Really, it's a lot about showing up on, that initial interview or the intake piece, at the discovery, and at mediation. So 3 big events. But other than that, we'll run the file in the background, so you're not having to deal with the day-to-day of the lawsuit. I think that's important because you need to be able to create a little bit of separation, right? You don't want to be reliving this abuse or the assault every day as you go through a lawsuit. You want to be able to put that on the lawyers. Now, the big question, I'm sure, the question that a lot of people have is damages or compensation. How much, and for what? So the short answer here is that I will never put a number on, the amount of compensation or the amounts that I think a case is worth when I first speak with a client. And the reason is because I don't know. I can tell you generally, these are the categories of damages that you might be able to claim for. The client might be able to tell me, these are the ways it's impacted me, but I don't have the evidence. We haven't gone far enough to know, can we hold the defendants or defendants responsible in law, and by how much? We don't know, what kind of evidence exists to prove those damages. So typically, even getting a good sense of how much a case is worth doesn't really happen until quite a bit into the lawsuit, or say closer to discovery, at least once we start getting that information. That being said, I think it's really important to know that, even a single sexual assault, and what some might consider, say, a minor sexual assault, I put that in air quotes because, if we're talking spectrum of touching to say, I don't know, the worst kind of abuse you can imagine, sure, some people classify this lower end abuse as minor sexual assault, but there really is such a thing. But say, it's a one-time incident of touching over the clothes. Even something like that can, in some circumstances, lead to pretty significant damage awards. And why I say that, and why that's important, is because when looking at, how much to compensate a victim of sexual assault or abuse, where courts will, the law will not just look at what happened. So, the severity of the abuse, or was the person in a position of power over you, what kind of acts happened, for how long, but they'll also look at the effects. And so, even if it's the kind of assault that you think, oh, well, it's nothing compared to some of the assaults and abuses I read about or something, others have gone through, that doesn't mean that you may not be entitled to significant, or you might, you at least have the possibility of seeking significant compensation. So it's always worth it, I think, to at least reach out and see, what your options might be there. So in terms of damages, though, even though I won't put a number on anything, I think the big categories of damages are important to know. So the first one is general damages, or pain and suffering damages, as we like calling them. So that one is a catch-all, or it's the sum that's awarded for, the effects of the abuse. So you can think about your psychological effects, the pain and suffering that you go through. Have you been diagnosed with depression? Are you suffering from anxiety as a result, right? Are you having PTSD symptoms of post-traumatic stress disorder? Are your relationships failing? Right? After an assault, has it changed your relationship with your children? Are you more wary, right? So there are a lot of these effects that arise out of sexual assault or abuse. So this pain and suffering bucket of damages captures, would be the one where all of those effects go into. Then there's a second category, or a second bucket of damages or injuries or losses, and that has to do with your economic damages. So we're thinking about past income loss. Did you have to take time off work? Did you quit a job? Right? Did you get let go because you were trying to cope with substances, right? You weren't able to show up on work on time, or you got more aggressive with others as a result of the abuse, or your interpersonal relationships failed, and so your job performance, attendance, all of that suffered. Did you have to take time off work to deal with the effects? That's a common one as well. So we're looking at those past income losses, but then we're also looking at a future. So it's this is more of a what if analysis, right? Future income loss. So it's a little bit of, had this abuse not happened, or had the assault not happened, where would you be? Where would you have been? And but in reality, this is where you are. So maybe you didn't get that promotion that you could have gotten, or if this happened in childhood, right? Like you dropped out of school, you never pursued university, even though all your siblings did, and that could have been a possibility for you, but because of what happened, you never went there. That was not an option for you anymore. So, or again, I know I talked about your personality or your relationships with people changing. Because of that, maybe you're not able to get from the roles you are in to managerial roles, or whatever the case might be. There's an economic damages argument that will advance as well. And that can be pretty significant. It's not something that everyone thinks about, but that can be very significant. Then there's what we call special damages, or out-of-pocket, compensation for out-of-pocket damages. So really, if you've, common effects, for example, of assault and abuse is using substances. A lot of my clients, will have had addictions. They might have needed treatment, and that can be very costly. So, expenses incurred for treatment, that's the result of abuse or assault, or the effects, right? To address the effects of abuse or assault, can be something there. You can also think of special damages as future costs. So, a lot of the time in cases we advance with sexual abuse and assault, we're thinking about future counseling needs, and getting the defendants to put something towards those future needs as well. Or if treatment is required, inpatient treatment is required, we're looking at that as well. And then punitive damages. So that's, it's a rarer one. It's not something that is very automatic, but punitive damages are damages that are awarded when the conduct of, defendants or defendants is just so egregious, so high-handed that it's just morally wrong, that the pain and suffering and all of these other all of these other pieces of compensation aren't enough. And so in these really egregious cases, then, we might make an argument punitive damages as well. And so now they're not about compensating the victim as much as punishing the defendant or defendants for their conduct. So things to keep in mind, these are the types of damages that you might be looking for, as in a lawsuit. Now, there's some other disparate pieces or some little pieces of information that commonly asked questions type of things that I wanted to cover. So the first one is about limitations, and statute of limitations might be a term that you've heard in real life or in TV, but limitation really just refers to, is there a timeline or a time limit to sue or to take action? So if we're thinking strictly about civil lawsuits, so suing a defendant or a defendant like a perpetrator or an institution or someone else for sexual assault or abuse, the general rule is now no. So limitation periods don't exist in Ontario on the criminal end or on the civil end. But if someone dies, so say the perpetrator of an abuse dies, then you only have 2 years from then to sue their estate. Or if we're taking a step out of the civil lawsuit context, and this is why it's important to kind of talk to a lawyer about all your options. Sometimes there might be other legal options like going to the Human Rights Tribunal or going through some other disciplinary complaint body. Those typically have limitation periods. So like, for example, the Human Rights Tribunal has a 1-year limitation period for most things. Well, not for most things, for sexual assault or sexual harassment. So it's important to talk to a lawyer about limitations. But the important takeaway I want you to have is that in sexual assault cases or sexual abuse cases, generally speaking, there are no limitation periods. And why is that important? It's because a lot of people will come to me, and say, well, this happened so long ago, right? This happened so long ago. What can we, I must be out of time. Again, not the case. So, there are avenues for justice in the civil world, regardless of how much time has passed. So it's always worth looking into it. Another question that gets asked often is about lawyers' fees. So I'm not going to speak for all lawyers, and I'm not going to speak for all of my cases even. But typically, if we're thinking about just a civil lawsuit, again, for sexual assault or abuse, a lot of lawyers will work on what we call a contingency fee. So what that means is you're not paying a big chunk of money up front as a retainer, but rather, the lawyer is going to take on that risk and the cost of a lawsuit. And then at the end, when it resolves, take fees out of the settlement amount. Now, obviously, there's a bit more to that, and depends on the agreement and the retainer agreement that you have with the lawyer. But generally speaking, especially if you're talking about sexual assault and abuse, a lot of lawyers will work on a contingency fee basis. So that's something to keep in mind. Even if you don't have money to pay for a lawyer, or a lot of my clients too, right? Like life has just become so difficult, either because of the abuse or other factors, that they just don't have the money, period. So that is not what's going to preclude you or prevent you from pursuing some justice. Now, the third point I have here is burden of proof. Burden of proof just is a fancy word for, the level at which you have to prove something. So in the criminal context, and maybe the contrast is helpful here, in the criminal context, you might have heard this concept called beyond a reasonable doubt. So because that system does not want to send any innocent or convict any innocent people, right? It's meant to make sure that, yes, you are sanctioning people who are actually guilty, but there's innocent until proven guilty is a very important piece of the criminal justice system. So for that reason, it has to be close to a certainty that someone committed, the assault or the abuse for them to be convicted, or that's the idea at least. So let's think of that as here, right? Like in the criminal system, you have to prove it at 99% sure that it happened the way, to prove the allegations. Civil is a very different standard. It's like half of that. So we operate on a standard that's called a balance of probabilities. So all I have to do is prove that it's more likely than not that the abuse or the assault happened as alleged. What does that mean? It means that we have to show that it was more likely. So think of it as like 51% or more chance that this happened. So it's a lot easier to prove in the civil context than it is in the criminal. So just because, say, you went to report to the police or you didn't report to the police, there wasn't a criminal conviction, or the police decided not to move forward with charges even, or whatever the case might be, that doesn't mean that you don't have a civil case. Again, it's very case by case, fact dependent. So worthwhile to at least speak to a lawyer if that's something you wanted to consider. So those are some, commonly asked questions, I think, important things to keep in mind. And I know for the sake of time, I think I will pause it here and kind of see if there are any other questions that you had that you'd like to ask.
Thank you very much, Anju, for this informative session. Please, for everyone who's following us on the social media, if you have any question, please type this question to the chat and I will read it accordingly. So far, I do have some questions myself. So, for example, when you've talked about limitation, don't you agree with me that since sooner is better, due to, regardless, yes, you've said that there's no limitation time for those cases, but don't you agree that it's recommended that as soon as you become aware of this violation, just to take an action, because that might be much better to save or to get something that you're entitled to?
Right. So I think in some ways you're right. So there's, limitations are its own area and can get pretty tricky. But yes, generally, if you are in a place to sue, so like if you want to go forward with this lawsuit and you are able to, then yes, I think, it definitely makes a lot of sense in most cases to go forward with the lawsuit sooner than later. Now, that being said, and also sometimes there is that argument that's made that, well, oh, you're out of time because you knew that, this happened, this affected you, you were ready to pursue a lawsuit, you even contacted lawyers before, but you chose to do nothing. And then 50 years later, here you are contacting us and, starting up a lawsuit. You shouldn't be allowed to do that. That's an argument that is advanced still, varying degrees of success. But I think the most important thing when thinking about timing is just, are you ready to do this? Because if it's shortly after a criminal process, right? Or say you went to the police and you reported it was really tough, and you just need time to heal. I would much rather anyone took that time to heal, recover from that, feel better, or at least move forward from that a little bit and feel ready to pursue a civil case, rather than just say, okay, we need to get this all done right now. Same thing with if someone's in a mental health crisis, right? I don't want to be signing on a client if they're having a crisis in a hospital or somewhere else, right? I don't want someone who's still trying to really get a handle on their active addiction, for example, right? And like to do this. So I want to make sure that any clients are ready emotionally, and like they're just set in life enough where pursuing this lawsuit makes sense. Because as much as I say that, there are 3 main events that a client has to show up for, and that, as lawyers or any good lawyers who work in this area should be making sure that the client isn't having to deal with this lawsuit all the time, we still need to be able to maintain a relationship with this client. So if they're really just struggling, if they're not ready and they start too prematurely, that can, do more harm to the lawsuit or your relationship with your lawyer or the progress of a case than just waiting a little bit.
Thank you very much. Well, okay. So another question: if there was a criminal proceeding against the violator, the accused in the criminal language, would that prevent the victim from filing a civil lawsuit at the same time? And if this has happened and then the outcome of the criminal action was to have that accused not responsible for a way or another, would that affect, are they both related to each other? Because you've said that on the civil action, we prove things on balance of probabilities, while we all know that everything in criminal world needs to be proven beyond reasonable doubt.
Mm-hmm. Excellent question. And you know what? That should have been on my slides. So you don't have to choose between criminal and civil. So you can pursue a criminal case, or you can, file that criminal complaint, and you can also have civil as an option. Now, in some cases, so like I mentioned the Human Rights Tribunal earlier as an option. If you're going to go forward with a civil case, you can't also have a Human Rights Tribunal case, and vice versa. But there are but in sexual assault abuse cases, that's more of the exception. Because you can have a criminal case, you can have a civil lawsuit looking for compensation, and you might even have a parallel complaint with, say, a disciplinary body. So if it's a teacher or a doctor or someone like that who abused you, their governing body, you might even have a complaint there that's also happening. So you can have many different proceedings related to the same issue. The civil action, though, is the one that really focuses on the survivor or the victim, in the sense that it's about the victim getting that compensation, but also it's the one where I at least personally find that the complainant has the most, not complainant, the survivor, the plaintiff has the most control, because you have your own lawyer, right? Like it's your case, you're advancing it, you have your own lawyer, you control things, and you make the decisions. I know the other types of processes, it's not necessarily the same. Say in a criminal proceeding, the Crown Attorney is not your lawyer. They're there to represent the state's interests. So likewise, the victim can oftentimes turn into this witness role instead of the person driving the legal proceeding. So the civil one gives them a lot more control. But back to the original point that you had actually asked about, what about the results of a criminal proceeding? I'm not going to say it has no impact. So the important place to start is, there's a different burden of proof, just because there was a, not guilty finding, or say, just not anything short of a conviction or a guilty plea in the criminal proceeding. That doesn't mean that you don't have a civil case, because you prove it to a different standard. That being said, there are times, right, like where if the decisions are so completely in the accused person's favor, say, after hearing the evidence, the judge has, there's a decision that says, well, I find this complainant to be absolutely not credible. Nothing that she has said makes sense. And this is a frivolous thing, or I found her to be lying. Again, that's an extreme example. And I say extreme example because I don't see that happening as much, not in the cases that come into me. But say you have something like that, then that can definitely hurt, a potential civil case, because the defense will want to rely on that decision and say, look, a judge found, even in their credibility analysis of the witnesses, this is what they found. Or what happens more than that, I think, is if you go to the police and they don't lay charges, or they invest, it doesn't go all the way to a conviction, then that might just make the defendant, or the perpetrator, alleged perpetrator, more emboldened. So they might feel like, oh, well, I wasn't convicted in the criminal affair. I was found not guilty. So therefore, why should I have to face accountability civilly, right? I can fight this too. And that sense of empowerment, I think, if anything, is something that, people who were accused and were not found guilty might feel in a subsequent proceeding. But it is again very case by case. So I wouldn't want a survivor to think just because the criminal case didn't go in their favor that there is no hope for them. I think you need to kind of have the lawyer work with you to look into what happened in that criminal case before you have anything further.
Of course, there is always hope. Hope is what keeps us alive. Well, let's hope all for the best. Okay, so in case of no further questions, let me check for the last time. Well, okay, so I think this would conclude our session. Thank you very, very much, Anju, for all of this wonderful information, and we are looking forward to have you again with us for another session related to the same topic. Thank you very much for your time and effort, and have a wonderful rest of your day.
Thank you, and thanks for having me. It's been a pleasure.